Lawyer and policy analyst Tony Dania joins me in the studio to better understand this development. Mr. Dania, thank you so much for coming.
Thank you, and good evening, viewers.
Indeed, an interesting twist to this development. Mr. President has now ordered the Attorney General of the Federation to ensure the immediate release of these minors. What do you make of this presidential intervention?
It's a good one, but I must say that we ought not to wait for the president. Every ministry has a minister. The police has an inspector general. So you should be able to manage it within the principles of the law and within, because the moral justification of your action. You don't need to wait for the president. And then I don't want to believe that this was a deliberate thing. Every person that commits an offense, yes, is presumed innocent, but if found wanting, the person should be charged. But our child justice system in Nigeria have not been properly organized, and it does not meet international standard practice. A child is any person that is below 18 years. That is the law. And a child of 7 years, in fact, you cannot say he has committed any offense, no matter what that child has done. A child of 7 to 12 years, it is only when you can determine that that child ought to know that what he's doing will amount to criminal liability. That is when you can try. Then, once it is less than 18, you can charge. But then, it has to be, there are there's procedure to this. We have the juvenile court. You don't take a child to the same court you take an adult to. Well, a judge sitting in the same court you take an adult to might sit in a juvenile court. I haven't said this. I felt disappointed when the police prosecuting counsel was ranting.
I was saying that they were not the ones arraigned, that they were family members of those who were arraigned.
You can imagine who sent him. These are people.
Can we say that a learned colleague was lying or something?
No. It's just eye service. Thinking that he's, he want to impress the president. He has the opportunity of speaking on air. It's not his responsibility to speak on air. The Attorney General's office has public relations department. The presidency has public relations department and Minister for Information. He should have kept quiet, most when he doesn't know what to say. These are people that consciously or unconsciously damages the position of governance in Nigeria. You see, there's no need to try to impress anybody. If you don't know what to say as at that time, you can say, well, the prosecution will react to this very soon. You know, we saw the children. We can't tell their ages anyway from the picture we have seen, but obviously there are children among them from the video we have seen. And why will you take almost like 60 persons to court at the same time? And then this brings us to the issue of the prison management. They are supposed to differentiate children from adults. We don't know where those defendants were brought from, whether they were brought from the adult cell or they were brought from a particular cell. Does the prison even have the section for children in their prison facility? These are the issues. So this will make the government to look more at child justice system in Nigeria.
We also hear Mr. President saying that law enforcement agents involved in the detentions will also be investigated and that disciplinary action will follow if any infractions are discovered. Is this an opportunity to right the wrong? Do you see any major thing coming out from here?
Yes. Like I said, the action of the president is okay in this context. But I suppose to see the Attorney General, a man we respect so much, taking the lead.
He actually did. I don't know if you were following the news when he asked the Inspector General, asked the Nigeria Police to transfer the case file to him.
And he reacted. I don't know if it is true. What we read is that he said it will be difficult to change the date and all that haven't been adjourned. Well, I openly disagreed with him with the most respect. If a date has been fixed by a court, you do what we call application for abridgment. It will be abridged, and you take your application. You can file the two applications together. The office of the Attorney General, yes, you can direct the police, but you don't need to wait for the police in an issue of serious national effect like this. You can call for the file. you can cross-check the ages of the children and immediately enter a nolle against those that are underage. Then you can call the Controller General or talk to your brother minister in charge of Interior to say, look, what is happening? Is it that the prison does not have a facility to take care of children that are sick?
But you just cited the Child Rights Act, a few minutes ago, and this is a decision of the court. There is the bail condition put at 10 million naira. Some argue is excessive and unattainable for most Nigerians. I'm just wondering, what part of the law, was the court operating with to have bypassed what was obvious to the eye, that these were minors and they have been detained for about 3 months?
The judge will act based on what he's given. The judge will not determine the ages, but a judge can ask, this child does not look like 18, this child does not look like 17. A judge can ask that question and say, look, I want to know the true age. A judge can do that. But otherwise, the judge will assume that what he has been given is correct until somebody brings persuasive argument to counter that position. So the judge was just assuming. So for the judge to grant a bail of 10 million, I don't know how true this is, but if it is true, then we must visit the issue. Don't forget, the charges are treasonable felony. So treasonable felony is a capital offense for which bail can only be granted on exceptional grounds. So unlike other offenses where you are entitled to bail as of right, but this one, no, you must persuade the court. And it is only the judge, a judge of a high court, that can grant bail in such situations.
So does Mr. President's intervention nullify the pronouncement of the court as it relates to fulfilling the bail condition?
The directive of the president is not to the court. It is to the Attorney General and to the Inspector General of Police. So they have to look for a way
to get back to the court.
Yes, to execute that.
To waive that bail condition.
Yes. So what they can do is simple. Apply for abridgment of time. That is, you have adjourned this matter to 1st of December. Please bring it back.
Next year, actually.
Yes.
I think it's January 2025.
Good. You've adjourned it to January 2025. Please bring it back to the 6th of October. The judges are human beings. They are in the society. I'm very sure the judge is seeing what is happening. He will grant that application. When it is granted, you can now argue that you want to discontinue prosecution against these people. And then it's done. The president can only grant mercy if the person has been convicted. He can grant mercy. He has that prerogative power.
So we're not expecting these individuals to leave the prison today.
The president cannot give a directive to the court or the judge.
They have to go back to the court.
They have to go back to the court. The directive is to the police, and the police should learn by this. There are lawyers who are ready to assist the office of the Attorney General. The Attorney General is a positively popular person before he became the Attorney General, and it's accessible, and so far he has been good.
Well, I am surprised about your position because some have thought that his decision to take over the case was an obvious shift in government's approach to this case, given the public backlash.
Of course, once a case becomes this controversial, the office of the Attorney General don't need any prompting from anybody. He can do direct intervention. So I'm not surprised. It's even impressive. He can take over any case, continue or discontinue any case. He has the constitutional power to do so. He can take over a case from the police. But this case, it is the police that have been prosecuting. I think it's not the office of the Attorney General. So it's a big lesson for all of us. We should look at how the police handles kids underage and children. Even non-underage, obviously malnourished suspects should be treated differently. When you see somebody that is sick, these children, from the physical view, you will know that some of them are children. You will know that they are not healthy, they are sick, they are not being well fed. So what has been happening? And you need to see the amount voted in the budget for feeding inmates in the prison and for medical care too. So this brings us to the offices that will need to, review their position on issues like this are: 1, the Office of the Minister of Interior; 2, the Controller General of Prisons; then the Inspector General of Police, particularly the prosecution section.
We're running out of time. I just want to get your take on the issue of conflicting orders from the court. The CJN touched on that recently when she asked the NJC to begin to investigate certain judges who have made conflicting orders in the case of Rivers. What's the import of this decision, and what are your thoughts in this regard?
This is to investigate a judge. Investigation of a judge is not a new thing, but you see, this could demoralize the judges and even cause issues for the justice system.
Is the multiplicity of judgment not already causing enough harm, not only to the judiciary, when Nigerians perceive it, but to security in some parts of the state?
Yes, the CJ can address the issue of multiplicity of contradictory judgment by courts of concurrent jurisdiction without, seemingly bringing to disrepute the integrity of judges.
By facing the NJC, I thought it was an investigation process. They're not proclaiming.
What are they investigating? Because you see, you must look at this. They cannot do criminal matter. They cannot try the judges in criminal matter. We got to hear today that Onojen, who was removed from office in 2019 and tried and convicted, his conviction has been set aside. He has been discharged and acquitted about 5 years after or so. Things like this are not good for the judiciary. And then imagine the delay. A whole ex-Chief Justice of the Federation, it took about 5 years for to get justice himself. Then you can talk of ordinary people like us.
What does that say about the justice system?
So having said that,
yes,
we are not against probing. What are they probing? The panel set up. What is the constitutionality of the panel? I don't want to preempt things. They can only do administrative investigations.
All right.
And then some persons or lawyers have had to write against judges, against lawyers. Investigation has a procedure. The NJC will take it. But when you come out and give it this kind of publicity and make a chief judge of a court a party to be openly investigated like this, it's not too good for the judiciary.
All right, good place.
It's a dangerous trend.
We're going to, continue this conversation subsequently. Perhaps next time when you come quite early, we'll have enough time to discuss this. Thank you.
You mean we are off?
Yes, of course. That's our show today. Tony Daniel is a lawyer and policy analyst. Thank you so much for sharing your thoughts with us on the program. Well, that's our show.